Hi, everyone. Welcome back to another episode of ABA Compliance and Legal Series. If you're planning to exit your ABA practice one day, which even if you don't think you are, you will plan on it one day, this is a conversation that you have to think about right now, not when you get an offer. Most ABA owners think about these things when they receive the letter of intent. In reality, valuation, deal structure, and even which buyers show up are shaped years earlier, often by compliance decisions that felt purely operational at the time. Today is episode 4, and we're focusing on how compliance actually affects real ABA transactions. We're joined today by Brandon Zarsky, a partner at Frier Levitt, who works directly on these deals. Welcome, Brandon.
Pleasure to be here. Thanks for having me.
Before we get into compliance mechanics, let's set the stage. Who is typically sitting around the buyer's table in an ABA transaction today? Is it strategic platforms, private equity sponsors, internal buyers, and how, very importantly, do their expectations differ?
Sure. There's quite a mix. You're looking at, I guess I would call them the existing practice buyers that are looking to expand. Most of the time, they're looking for what I would call an add-on or a bolt-on practice, which is adding an existing ABA practice to what may be a conglomeration of pre-purchased ABA practices or just a large, organic growth practice. In terms of private equity, there's definitely a private equity interest as well, but private equity is looking generally for one of two things. They're looking for either what I would call a platform practice in a new jurisdiction. And what I mean by platform is a large pre-existing platform that is in a geographic region, already has a lot of providers, a lot of sway, and can be used as a way to add additional practices on. So private equity will generally come in first looking for a platform target. That platform target will generally be assessed at a higher value. And after it's acquired, it will then be used to essentially add on more practices in that geographic region. Sometimes platform practices, go across multiple jurisdictions. Sometimes PE firms choose to have platform practices in each different jurisdiction. And that also varies depending on each jurisdiction's rules regarding what types of professional entities can function there. PE is generally looking for either platform practices or bolt-ons, depending on whether you're a large practice that's considered to be a platform that they can come in on. That's generally the ideal situation. Bolt-ons usually receive a lower multiple, generally lower purchase price. That's not always the case. And, depending on whether or not you're a strategic acquisition for the PE firm, that may vary. Finally, you have your strategic buyers. This is something that may come after a PE transaction, or you may be brought in, once again, depending on if you're a unicorn practice that fulfills a very specific role. PE is usually going to come in and exit within, I think the average is between 3 and 7 years, with the average sitting at around 4. Strategic buyers are generally in for the long term. So the transaction structure and the types of compensation arrangements that you're going to get are generally going to vary from PE, which is going to be a mix of generally rollover equity and some kind of cash payout, which can generally be over a period of years.
Looking at from the prism of compliance, do they look at compliance from a different angle, each one of these 3 potential buyers?
There's going to be different weights placed on different compliance factors based on the type of buyer. When you look at private equity, you're looking at a purchaser that is looking to vastly increase the profitability of the business in the next 3 to 7 years, and then go to what we would call a second sale event, with a strategic buyer then coming in and purchasing, what the PE fund had come in and built up.
And how would that be reflected in compliance? What would they be looking for specifically that the other ones will put less weight on?
It might not necessarily be in legal compliance, although they are going to be very concerned about that from both a federal and state perspective. But they're primarily going to be looking at whether there's contractual structures in place to make sure that they can lock in the current producers at the business for a certain period of time. So, for example, are there assignable employment agreements with covenants? Are there governing documents that create certain responsibilities on the current owners? Is there a certain level of compensation that's going to the current owners that can be modified by the private equity model in such a way to create value over a period of time that then, allows them to create more EBITDA value, therefore driving the value of a second sale? Those are things that they're probably going to be much more interested. Strategic buyers are going to be interested in long-term structuring and making sure that, what they're purchasing is going to be stable and makes sense, especially if they're adding it onto a larger national model that's pre-existing and intending on being there. In terms of compliance, though, I think that all of them are going to look at your state law and your federal law compliance under a microscope, and it's going to matter a lot towards value. Ultimately, the valuation that you receive and the EBITDA multiple that your business receives is going to be based entirely on the risk that the buyer is going to take on. So even if it's a PE buyer, a strategic buyer, or a pre-existing practice that's trying to add you on as a new practice location or care center to their existing model, they're going to be scrutinizing, your bill submissions, your audit history, the structure of your business, and additionally any issues you've had in the past. So for example, are there any pending investigations of your business? Are you on prepayment review? Are there issues that you've had with employees? Are there liens, judgments, et cetera, on your business? All of those things are going to impact the overall risk profile of the business, which is going to in turn have an impact on the overall multiple. Additionally, that's going to vary based on whether or not you're being considered as a platform practice or an add-on practice. So for example, certain risks are going to have a larger impact on your overall multiple. And platforms also generally, we're talking 7, 8, 9 plus multiples for these types of large, very valuable businesses that can create the ability for a PE firm to come in and control an area or geographically, versus a bolt-on. That may be the case depending on if it controls a small, very important, densely populated region, for example, or if they have very, very high tier providers that command a lot of respect and can be used for brand value.
So compliance isn't static, it's contextual to the buyer and the capital behind the deal. How is the current regulatory environment influencing how buyers assess compliance risk in ABA transactions?
There's a serious deep dive that every buyer is going to make as soon as they come in and look at a practice. They're not just going to be looking at just your state and federal compliance, but additionally how you've set up the business, how you've managed the business, and how the business is structured in terms of the jurisdiction that you're in. In terms of, high level of regulatory scrutiny, the main things that buyers are going to be looking at is going to tie into your profitability. So like I said earlier, what's your audit history? Are there ongoing investigations? If you're on prepayment review, that's obviously a huge issue. How are you structuring your supervision, your note taking? And there's a mix here of best practices, by the way, and legal compliance. And buyers are going to be looking at both of those things. So for example, even if a state's, laws aren't specific that notes should be taken contemporaneously each day and saved into a file, buyers are going to be looking at things like that when they're analyzing, the overall risk. Structure and the post-transaction structure is also going to matter when we think about this, right? So are we talking about an asset sale or are we talking about a stock sale? Is there going to be a combination of the two utilizing an MSO model, which is very common because we're in many jurisdictions, consider ABA professional service, and we're thinking about corporate practice considerations, and in those types of transactions, a PE firm's generally going to either purchase a pre-existing MSO or come in with their own MSO that's going to purchase the non-clinical aspects of the business. And for those who are listening and don't know, an MSO is a management services organization. It's a very common structure in healthcare models, which allows investment in a revenue stream by a non-professional or non-professionals. It's very commonly used by private equity in states where they're prohibited from directly owning or controlling a type of professional entity, medicine, law, ABA, accounting, any other kind of, professional mental health service, things like that. That structure is going to be a purchase of assets, but depending on what happens with the clinical entity, compliance may matter more or less in terms of what you've done in the past. So, and when I say that, what I mean is you may have a new clinical entity coming in, what I would call a friendly captive practice that is owned by a provider that's friendly to the PE firm or the strategic acquirer or the existing practice. And they may come in and take your providers, move them into that entity and use that entity going forward. Conversely, in some transaction structures, they may keep your pre-existing entities. For example, do you have good vendor contracts? Do you have good rates? Will it be difficult for you to assign things over to a new entity like clinical employees, which is why employment agreement compliance and assignability is important. The reason I bring this up is because compliance may matter more in a situation where you're using the same clinical entity because it's going to be subject to liabilities that occurred prior to the closing of the transaction, which will have a direct impact on the earnings or potential liabilities incurred by the buyer. Conversely, where you're just purchasing assets and you're using a new clinical entity, the buyer may not be as concerned. But that's going to vary pretty substantially based on jurisdiction and the model that the buyer is using.
Let's say they do an asset sale. What happens with any previous claims?
So there's always a question of successor liability, but for purposes of just simplicity, if a PE buyer is coming in and they can't own directly, but they can create a new entity in the jurisdiction owned by a friendly, I'll call it the friendly provider owner. That new entity will be a new distinct legal entity that will come in. Generally, what they'll ask for is an assignment of workforce in place that will happen at closing. So your providers will move over to the new entity. In many cases, provider owners may then become employees. And we can talk about how that's structured into the transaction structures later on. But basically, the idea is you would create a new clinical entity, move the goodwill over into the new clinical entity and management company. The non-clinical assets would move into the management company, which would be separate and apart and not provide clinical services, also insulating it somewhat from clinical liability, professional liability. And that new entity would then provide services going on. That may not always be the case. In the instance where you're continuing to use the same clinical entity, liabilities that occurred pre-closing may impact the profitability of the business. If, for example, say there's an audit on monies coming in, and now the PE buyer, which is structured as a management company, is extracting a management fee that it is not realizing because the revenues have now been decreased by, monies that are being held up in an audit. Well, that obviously is going to impact their bottom line, and that may have an impact on, the folks that received the purchase price, whether it was employees or just owners or a mix of the two. And there may be indemnities and other, provisions built into the purchase consideration and the purchase agreement that may impact, the ultimate payout. So, for example, it's pretty common in these types of deals for there to be a lump sum cash payment right at closing to make everybody happy. But then what I would call golden handcuffs in two different ways. One, there would be, cash payments over time, usually a period of years. So if you think about a PE buyer that's looking to exit in 3 to 4 years, they may say, all right, we're going to give you, 50% of the consideration at closing, but then the rest of it is going to come in tranches, maybe at the 2-year mark and the 4-year mark. Reason being, they want to keep the producers in the practice to make sure that the practice maintains the same level of profitability and they can scale it. Alternatively, another thing that's very common is for PE firms and any other strategic buyers to grant what I'll call rollover equity units in either the MSO or a holding company in the MSO that they're created. And what these essentially are membership interest units in an LLC or stock in a corporation that don't provide any right to cash revenue as the business goes on, but would allow you to participate in, for example, the second sale event with the strategic buyer.
Oh, that's an interesting structure. Getting back to the regulatory environment. So the regulatory environment, do you see a shift recently in how they're scrutinizing ABAs? And if so, how's that impacting ABAs that want to be sold going forward and how the potential buyers are looking at it vis-a-vis the way that they were operating until today?
I can say that there's definitely been an increase in regulatory scrutiny on ABA transactions, but the same can be said to actually private equity transactions in healthcare across the board. We've actually seen a ton of state legislation that's been popping up, and some jurisdictions have been passing legislation that have made transactions with private equity MSOs much more difficult. And that's obviously having a huge impact on whether or not private equity funds are willing to come in and assess very large multiples on purchases. Like I said earlier, the multiple that you're receiving is essentially, the degree of risk that the PE fund is willing to take on in connection with the purchase price. And when you're looking at an increase in state and federal, attention to these deals, state on the corporate practice of professional services side and federal just on the overall kind of corporate practice. Believe it or not, we've actually seen the federal government look at corporate practice issues in certain areas and use them as a target for whether or not, claims that have been false based on the structure. We're starting to see that. So I would say it absolutely has. That's not to say that there isn't still a lot of interest in this area. And, things have been moving back and forth. Administrations have changed and there's been a slight change, but not a huge change in attention. I also think that as state governments change, especially governorships, there is a pretty big shift from side to side on this attention to private equity funds. For example, New York State a couple of years ago had legislation that was going to require, massive disclosures in any healthcare transaction. So this would apply to ABA, would apply to medicine, psychology, mental health, you name it. It would have required massive disclosures and an approval process from the state government for any of these types of management contract transactions. And right before that bill went through, it got to the governor's desk, it was massively slashed and modified to just be you need to notify us, but there's no approval necessary. You can kind of see how there was a shift even within the New York State government on how they wanted to approach that while the bill was making its way through government. But that's happening across the country. In some areas more than less, but I would say in densely populated states, it's happening more often.
Does that make an asset-based transaction much more desirable? And is it trending in that direction?
I don't think it has a huge impact on whether it's an asset or stock sale, because one of the issues with an asset sale is that it's going to be an asset sale to an MSO. And where you're really seeing scrutiny right now is on the level of control that these private equity-backed MSOs tend to exhibit over clinical services. Whether it's ABA, medicine, dental, state and federal courts have found issue with the level of control that's actually been exhibited by these MSOs. And what I mean by control is specifically control over clinical practice. Generally, government is okay with some level of MSO control over strictly administrative tasks. But one issue we've seen is a slow rolling bleed over of that control into clinical decision making. So that may start off as the MSO providing some level of oversight on who are we hiring and firing in terms of clinicians, or maybe we're just gathering resumes, to then it gets to the point where the MSO is actually making recommendations to the clinician owners on who should be fired. And then it gets even to the next point, which a lot of states like New Jersey, for example, the New Jersey Supreme Court in a case called Allstate versus Northfield Medical Center took issue in the context of a medical practice MSO, but that's now bled over in New Jersey into all different types of MSO models. And in that case, the MSO had really taken a very, very aggressive approach. For example, it had a pre-signed resignation document that allowed it to essentially provide the provider owner with a document that said, oh, by the way, you quit today and you've appointed your new successor as our new favorite owner. You can see how that might have a problem and influence, clinical decision making. Ultimately, corporations are out to create value for their shareholders. In the converse, professional entities and especially clinical entities are there to benefit their patients. That clashes just naturally. The two things cannot exist. So you're starting to see state governments especially taking notice of this. Whether we'll see massive changes in most jurisdictions, I don't know, but a couple have made some pretty substantial changes and are requiring a lot more. We'll see if that continues to be a trend. If it does, I anticipate that we're going to be seeing probably lower multiples and less interest, but I haven't seen that yet. So, things are still rolling along.
Is that being played out in the form of tighter CPOM enforcement and regulation?
Absolutely. You're not only seeing more scrutiny from a corporate practice front, but you're also seeing an interest from a legislative front. Originally, the corporate practice doctrine in a lot of states was something that was very legalese oriented. Not a lot of people were even really aware of it. Some folks still really are not aware of it at all, which is a problem for us a lot when we're coming in and evaluating practice structures. But it's becoming more of a public interest concern that's leading to legislative change. And by that, I mean, folks are starting to realize, I don't like going into a CMOT, any kind of healthcare provider and feeling like I'm in, like a healthcare mill where I'm just being worked through in a 10-minute appointment. I don't want to drop my kid off and feel like they're not getting the amount of time and treatment that they need. And people don't like that. And it's something that, from a public policy perspective, draws a lot of attention, especially in the context of ABA, where we're talking about therapy for kids. From a public policy standpoint, a nightmare for some of these private equity backed MSOs. That being said, I haven't seen a huge sea change. There's certainly stuff that's happening across the country in various jurisdictions, but we're continuing to do deals. There's still a lot of interest until there's a major change in that, and we see something across the board federally or states. There starts to be a snowball effect across the states. I don't think there's going to be massive change, but that could occur. And we're certainly seeing a public interest shift in that front.
But you haven't seen any results driven from that at this point.
There was some back off a couple of years ago when some of these laws were starting to come out. And there's been a little bit of backtracking. There's certainly still deals happening. I will tell you, it's probably not as busy as it was maybe 4 years ago, 5 years ago. But at the same time, we were right before COVID. That's actually like 7 years now. Right before the pandemic, there was a lot of attention. Then the pandemic happened. A lot of models were really tested. The ones that survived many of them continue to operate. Some of them taken on strategic buyers. And now, we've seen, a return to there being more deals. I don't think it's quite as busy as it was, but it varies from sector to sector and from specialty to specialty. And certain geographic regions have more deals than others. I'm seeing a pretty big uptick on practices that were maybe not PE backed, but single state, that are now moving into multi-jurisdiction models, especially in mental health. That's something that we've seen across the board in the last couple of years. I'm excited by that. I actually like that model, and it gives a lot more access. It can give a lot more access to care. It's certainly something that's interesting. We'll have to see how it evolves.
When buyers review compliance during diligence, where does their attention concentrate first?
I could talk about this for like an hour, but I'll try to distill it. So you're going to have 8 key areas of focus here. You're going to have your organizational documents and your structure. They're going to want to look at, how is this thing set up? Is it compliant with corporate practice of medicine rules? Specifically, is there already an MSO structure in place if there are non-clinical owners in a jurisdiction where there's CPOM restrictions? And then they're also going to look at the governing documents, and they're going to specifically look at certain things in those governing documents, specifically how are capital proceeds, the proceeds from like a purchase of substantially all the assets distributed. And are there restrictions? Are there built-in ways of locking in the owners into staying there? And what are the voting requirements to approve the transaction? Because those things can sometimes, cause major issues in getting things approved. And if, for example, say there's a rogue owner that left and you require unanimous vote to approve a transaction, that could be a huge issue, because if you didn't get a release from them, the PE fund may require that you do, or they may require that you escrow a large portion of the funds, maybe even a percentage of the funds based on what they would have received pending, the expiration of a statute of limitation on a claim by this person. That's a huge issue. And not necessarily compliance, but something that everybody who's considering a sale should be thinking about. And not just when you're considering a sale. This is something you should tackle like years in advance, even potentially when you're setting up the entity. Second, you should think about the assets of the business generally. Specifically, are they encumbered and how? One huge issue that we're seeing right now is where practices received SBA loans just due to the just tortuously slow speed that the SBA processes any kind of application, even an application for shifting a loan or paying off a loan or entering into. A lot of these loan covenants require that you get their permission to enter into a deal. That can be a huge issue. Encumbrance of assets is something you should consider. In terms of legal compliance, I think we touched on a lot of the issues already, but they're definitely going to be looking at your billing and your coding practices. Basically, every practice that's considering one of these transactions, we recommend get a certified professional coder and like a coding consultant to come in and do a internal audit of your practice. That is gold, because if you can figure this stuff out in advance and correct it, they're going to come in and do the exact same thing. And that is going to directly impact the risk profile that they assign to your business based on your past and what they will consider to be your future processes. For example, do you have providers that are consistently failing to enter their notes? If you have behavioral techs, are they being properly supervised? Are they meeting the minimum requirements? Things like that. They're also going to look at, for example, If you are providing services in schools, how's that being done? Do you have an office in that school? That's a major issue in ABA transactions that we've seen come up in terms of, then they're going to look at litigation investigations. Clearly, that is something it's very important to get ahead of. Talk to your legal counsel. You don't want to over disclose, but you need to disclose. There's going to be representations and warranties in the deal documents that apply directly to, ongoing litigation investigations. And they may, whether or not you have one, it may impact your multiple, and it may also impact the purchase consideration. So, for example, there may need to be an indemnity escrow to deal with an audit or an investigation by CMS, or a potential malpractice lawsuit that may be ongoing, or even just a slip and fall at the premises. These are all things we need to consider. Outside of that, contract compliance is super important, especially in the context of PE deals, because they're going to be looking for two things for all your employees. They're going to want to make sure that you can assign their contracts to a new entity if that's necessary for the structure. And if there are restrictions, they're going to want to make sure that they're enforceable and assignable. Once again, the idea being the buyer wants to make sure that in the new structure, or even if the old practice continues to function, that they're going to be continuing to generate revenue at the same levels as pre-closing. That's also going to be factored into the multiple and the compensation you get. Finally, licenses and permits, something to consider, making sure those are all above board before you go into anything. Believe it or not, we've seen disciplinary mental health entities that have had providers that until due diligence, we weren't aware that, their license may have lapsed for a period of years. That can be a major issue when the purchase price is directly tied to the number of providers that are coming over and how long they're going to be locked in, whether through covenants or different types of, consideration that they're going to receive post-transaction. And then finally, financial and tax matters. It's really important to work with your accountants and potentially financial advisors to consider getting a quality of earnings report before you go to market. That's like something that a lot of people don't do, and they just start shopping around and get LOIs from folks. You really want to be presenting yourself on a silver platter, just both from a compliance standpoint and a financial standpoint, to maximize value. That's super important.
So looking 3 to 5 years before an exit, what compliance issues later become material once the deal process begins?
So definitely your organizational structure and documents. That's the first thing. You need to be considering, all right, am I completely provider owned in a CPOM jurisdiction? Okay, I don't need to worry about an MSO or structuring that, but are there non-provider owners, and does my jurisdiction prohibit non-provider owners? Then we need to think about, okay, how are we going to structure this thing? Generally, you're going to do it through an MSO, get competent healthcare counsel that specializes in your jurisdiction's CPOM restrictions, have them structure your business. At the same time you do that, you should be thinking about structuring your organizational documents to contemplate a sale, even if you have no interest in doing a sale. And I tell this to every single business we set up, not just folks that are considering a sale when we speak to them, because what you're doing when you do this is you're generating value that you may not realize right away, but that you will lose if you don't do it early on.
Are you saying that every clinic should be set up as a MSO, even if it's owned by clinicians and it's not in a CPOM state?
Not necessarily. I will say I think that having an MSO is great because it does provide some benefits outside of corporate practice structuring. For example, just from a very simple standpoint, liability protection. I mean, now you've got a lot of your assets in a non-clinical entity that's not rendering clinical services and is outside of that sphere of liability. It still can happen, but assuming that you are running the MSO correctly, it's not overstretching into making clinical decisions, then there's a level of asset protection there, and there can be tax benefits as well. So MSOs can be useful. I'm not necessarily saying you need that, though, although you should always consider it. What I'm saying is you should have governmental documents, for example, an operating agreement or shareholders agreement that contemplates what happens in a sale, contemplates exactly the vote required, and is very clear on, drag along, tag along rights, anything that could potentially apply to a sale. All the partners should be in agreement on how that should work. Everybody should sign it, and anyone who comes on should sign a joinder to it so that it's clear and unambiguous what the rules are, because PE firm's going to come in and they're going to look at that first to see, can we even do this deal? So that's the first thing. The second thing, I think if you can, annually or biannually, do that internal audit I discussed earlier. Get a certified professional coder, look at your billing practices, look at your record keeping practices, look at your supervision practices, talk to a lawyer in your jurisdiction and figure out, what are there specific rules? Are there hour requirements on supervision? Are there limitations on the amount of providers that can supervise? These are all things I would do every year, 2 years. If you can do them every 6 months, great. It's going to depend on the size of your practice, how often you should be doing this, but it's incredibly, incredibly important. Outside of that, I think that contracting is very, very important with your employees, but also every single time you enter into a vendor arrangement, or you consider an arrangement with a patient that could be considered remuneration in exchange for that patient receiving services from you, or remuneration to a provider in exchange for that provider making referrals to you. You need to be careful and talk to legal counsel about it, because those types of things can create real concerns, both from a federal anti-kickback statute perspective, but also a state fee splitting perspective, state anti-bribery, state self-referral. And these can be things as simple as paying for diagnoses in connection with then receiving ABA treatment. That's a huge issue. Sublease arrangements, for example, are you renting, and this happens, believe it or not, are you renting a closet in a provider's office for thousands of dollars a month, and that provider sends you a bunch of referrals? Because that looks very, very bad, and it's super low hanging fruit if you're receiving federal reimbursement. By the way, the OIG, Office of Inspector General, just loves to target these lease arrangements, and we see them all the time. You really got to be thinking about all of that. Vendor arrangements with referral sources, and arrangements with marketers as well. You should not be paying marketers to generate referrals for you, especially not on a 1099 basis. There's specific safe harbors and rules that can apply. Not all of these things are necessarily problematic, but you should be talking to legal counsel upfront about these things, so that make sure that you're either not doing them if there's no way to make them work, or that if you are doing them, they're carefully tailored to meet a safe harbor or an exception to one of these laws. So, for example, for the federal anti-kickback statute, there's numerous safe harbors. There's safe harbors for patient transportation, safe harbors for providing all kinds of different services. But the important thing to note about these is generally there's going to be a number of elements that you need to meet, and you need to meet every single one of them specifically in order to meet the safe harbor. And that may require that you have a written contract in advance, in writing, that payments between the parties are not made based upon volume or value of referrals made. And you have to meet each one of those things to be safe. Otherwise, you're potentially subject to scrutiny. And that's something that, if for example, a purchaser comes in and they find that in due diligence, and they will, they're going to say to you, all right, well, we either need you to escrow money to cover indemnity, or in certain instances, they may require you to make a self-disclosure to the government and essentially tell on yourself and pay a penalty before they're willing to go through with the deal, because they just will not touch that. And that's something people really, really do not anticipate.
Can you break it down for us, just like very briefly, the issues that if you don't take care of 3 to 5 years before, there's nothing you can do to remediate it at the time of the sale, and the things that can be remediated quite quickly once it's time to sell the company?
Sure. In terms of just the legal compliance issues I just talked about. So specifically, your corporate practice structure, because, as a side note, that's also a federal and state concern, because if you are structured incorrectly, you're operating illegally, then there's an argument that every time you submit a claim to the federal government or a commercial payer, you are making a statement that we're operating above board. This is a legal claim. Nothing, the business is fully in compliance. So you should be thinking about all the things that you can't turn back time on. Am I structured correctly from a corporate practice standpoint? Am I billing and coding correctly? Do I have vendor relationships that are potentially fee splitting? Am I potentially, remunerating patients in exchange for them using my services over another provider's services? Am I waiving charges? Am I providing free transportation that doesn't meet the free transportation safe harbor? All of these legal compliance issues, you can fix them at closing, go forward, but the impact of the time where you were out of compliance, you can't fix that. You can't turn back the clock. You should always be thinking about things like that, where your past actions can impact not only the value you receive in the sale, but potentially your obligations following the sale. For example, do you have indemnification obligations? Are the prepayments the subsequent payments that you're going to receive going to be reduced? Are they contingent on there not being any of these types of issues? Is your rollover equity contingent on there not being any of these kinds of issues, or can your rollover equity be terminated if, for example, the purchaser determines after the closing that you were involved in something that had a material adverse impact on the business? These are all the major things that you really need to fix in advance. Also, I would really, really encourage businesses to think about their organizational documents, specifically for businesses who have a wide range of people who are in different parts of their career. You have new providers, you have providers that have been building the practice for years. Exits are very different for, providers at different stages of their career. And, providers who built the practice for 20 years may be thinking to themselves, well, I really built this up. What should I be entitled to? Providers that are just coming on or have been with the practice for a few years may be thinking, well, I'm the revenue generation following the closing that's building itself into the purchase price. So these types of things are way harder to negotiate. You can do it right before a closing, but good luck. This is something where you want to figure these things out in advance, so you're not fighting over them right before you're about to receive a large sum of money and enter into an extremely material transaction that's likely going to have a substantial impact on your life for the next 3 to 5 to 10 years. Those are the things I would focus on.
Would you say that mostly these impact the sale price or the structure of the deal?
It could impact both. Like I said before, the multiple that's going to be assigned by the buyer is going to be based on a risk profile. So I think it's going to have a direct impact on that. It could take you from a 10 down to an 8 or down to a 6, depending on how bad things are, or it could kill the deal. And then I would say it almost always is going to have an impact on the post-closing relationship, because the nature of these deals is that the person acquiring the business needs to continue to realize the revenue that you were generating pre-closing. And in most cases, they want the ability to use their infrastructure to bump that. That means that, they need to have folks that are going to be around and continuing to generate revenue, like I said earlier. And that means that, like I said, the payments are going to be structured over years. Rollover equity you're not going to see a benefit to that until a second sale event. And you're likely going to be subject to pretty serious restrictive covenants. All of those things are intended to keep you around. And if these risks are known in the diligence process, there's likely to be indemnification requirements that are going to be built in that are going to impact you, could impact you post-closing, and could impact how the consideration is paid out. For example, if there's a very large known liability, the buyer may insist on an indemnity escrow of some kind, a percentage of the purchase price. It's not uncommon to see that anyway, but if we're aware of a very large audit or a very large concern and it's ongoing and won't be resolved before the closing, you can anticipate that type of risk for them is going to lead to them asking for some kind of coverage. They don't want to give you the money if they know they're going to have to come clawing it back. Ultimately, they may ask for you to put it in an escrow for a period of years to make sure that they can get it back if they need to.
If it is an asset sale and there was recoupment by a payer, how would that work? The old company's gone. This is a new company. Where would they collect it from?
So likely what they would do is ask the recipients of the purchase price to jointly and severally indemnify those losses, and they would potentially escrow monies at the beginning to, cover that. In addition, like I said, a lot of what folks receive in these types of transactions isn't received necessarily at the closing. So, for example, in addition to an indemnity escrow, if you're going to receive $1 million on closing, $1 million and $500,000 at year 2 and $500,000 at year 4, they may also reserve the right to, for example, reduce the deferred payments that they're going to make to you based on liabilities incurred based on pre-closing actions of the practice, is generally how they handle that.
Even in an asset sale, you're saying that the repayment follows the assets, not necessarily the clinic?
It depends on whether or not the repayment has a direct impact on the ability of the PE firm to make money. So, for example, and remember, there's always most likely going to be an asset sale to an MSO, but there may or may not be a stock sale from one end, you may not have a new entity on the clinical side. And because the way revenue flows to the buyer, in most cases through an MSO model, if you have a professional entity that is now having to make a recoupment, the way that the MSO receives money is through a management fee based on the revenues that that entity is making. So now there's no money to pay the management fee. So now they're being damaged, they're suffering losses, and that's going to lead to a contractual right for them to sue for indemnification. But it really depends on the structure and whether or not that loss carries through to the buyer.
Let's end it with something constructive.
Sure.
Are there compliance systems or operation disciplines that buyers interpret as signs of maturity and scalability, not just risk mitigation?
Yeah, absolutely. My advice to clients when they're thinking about going to market is you really should be thinking about the deal that you want before you start shopping around. And that involves showing up with friends at your side, and by that I mean make sure that you have the correct representatives, and that's likely legal counsel that's done these deals before, really good accounting professionals that understand your business and also have been mitigating risks for your business and can explain that. Show up with a quality of earnings report, show up ready and willing and able to describe exactly any issues that you have had in the past and how they've been remediated. Do that internal self-audit. And one other thing is, depending on the size of your business, consider talking to a broker, because there's a lot of different deal structures. I went over a very high level description of what I see most commonly in all kinds of different healthcare transactions, whether it's ABA, medical, dental, et cetera. But there are different types of structures. There's minority investment structures. There's structures where, the providers may remain, the original owners may remain owners in the practice going forward. Based on what you want to do, show up to the table knowing what you want and talk to the people that are willing to offer you that. A lot of times talking to a broker, that broker can get you in front of the right person or the right group of people. And then you can choose from a set of options that really align with what your ownership wants to do. That's super important, because you don't want to just go to market and get a bunch of offers and maybe you're not talking to any of the right people and you end up with a deal that's completely different than what you wanted. You're going to get a worse deal in that instance as well, because you're not leveraging the things that you have that are really your strong points. Do you have a really great clinical ownership that a great partner is going to want to stick around and incentivize? Are you really looking for a strategic long-term partner, or are you just looking for a PE transaction? Those are very, very different things. So targeting who you're speaking to and how you approach them is absolutely important. And approaching them with the quality of earnings report, approaching them with sell side diligence, showing them immediately that your governing documents are clear. If there's any issues that you could encounter, for example, in that example of like a rogue owner that never signed a release, can you deal with that before you even go to market? That way, when they ask the question, you can just hand them the paper and it's not an issue. That absolutely changes the risk profile. And I absolutely think it can really influence the type of buyers that you're even looking to work with. Because there are certainly buyers that are looking for long-term partnerships, and there are sellers that are looking for long-term partnerships. If that's something you're looking for, maybe PE or traditional PE is not right for you. That doesn't mean there's not a transaction out there that's right for you.
Thank you, Brandon. That was extremely insightful. And I think you've opened up a new vista to many ABA owners' worlds where until now compliance was just about audits and clawbacks and recoupment. And you've shown us that the exit will depend on it, how your deal is structured, who's willing to buy you, how much risk you carry after closing, and how quickly a transaction can move. Anybody out there, if you're building an ABA practice today, you're also building your future exit, whether you're thinking about it or not. Thanks for breaking this down in a way that's practical for operations. And everybody listening, we'll continue with this series next week. You're all free to reach out to Brandon. You can look him up online, or Brandon, if you want to share contact details, you're welcome to do that.
Absolutely. You can feel free to reach out to me at bzarsky@frierlevitt.com, or you can Google me and I should pop up right at the top. And if anyone has any questions, I'm more than happy to have a chat after the podcast, and I hope to connect with some of you. Thanks again,
Brandon. Thank you.
Take care, everyone.